Good morning, members. A very good new year to you all. This is the first meeting in the year of the snake. I wish you all good luck, good health, and wisdom. I now call to order the meeting of the Bills Committee on Protection of the meeting of the Bills Committee on Courts Remote Hearing Bill. Now, follow-up actions since the previous meeting. CB brackets 2 169 2025 01 and the reply submitted by the Judiciary CB brackets 2 169 2025 02. I'll now invite Mr. Jose Yam, Deputy Judiciary Administrator, to walk us through the reply. Members who would like to ask follow-up questions, please press the Request to Speak button in front of you. Mr. Jose Yam, Deputy Judiciary Administrator, please. Ready when you are. Good morning, Chair and the members. As per the direction of Madam Chair, I will walk members through the administration's reply to the follow-up matters from the previous meeting concerning contempt of court. Under the common law, contempt of court is divided into two categories, that is civil and criminal. Civil contempt of court is committed when a court order or an undertaking given to the court by a party in a proceeding is disobeyed. The mens rea required is merely an intention to disobey the court's order or undertaking. Examples of conduct which are regarded as civil contempt of court include disobedience to an order for the payment of money to court in time and disobedience to a judgment or order to do or abstain from doing any act within a specified time. Criminal contempt of court is committed when such conduct interferes with the due administration of justice generally. Examples include disobedience to a witness summons to attend a court hearing, disrupting court proceedings, and insulting judicial officers. Under Part 2 of the bill, a remote hearing order is made, varied, or revoked by the court if it is satisfied that it is in the interest of justice to do so, after considering the factors as set out in the Clause 9 of the bill. If a participant disobeys a remote hearing order from the court and fails to attend a remote hearing, the conduct may attract the same consequences as if the remote hearing were a physical hearing. We would like to clarify, however, that Part 2 does not currently state in any certain term that such conduct would attract the consequence of being cited for contempt of court. While such conduct may indeed disrupt court proceedings, thereby undermining the due administration of justice, but civil contempt is also a possibility, considering that it involves a breach of the remote hearing order. It should be further added that contempt of court, given its severity, is generally treated as the last resort to be utilized if the court is unable to enforce its orders by other means, including but not limited to appropriate court orders. As we have mentioned in a reply on the 17th of January, that is CB brackets 291 2025 brackets 2, on pages 7 to 8, the consequences of failing to attend a remote hearing on order does not limit to contempt of court. Now, concerning the phrase for all effects and purposes, Part 3, that is clauses 10 to 21 of the bill, concerns the operation of remote hearings. We have introduced some deeming provisions, such that a remote hearing is regarded the same as a hearing in a physical setting in all relevant aspects. The phrase "for all effects and purposes" in clauses 10, 15, 19 brackets 2, and 21 brackets 2 is meant to express that the relevant actions taken in a remote hearing are deemed to have the same effects and purposes as similar actions taken in a physical hearing. We have heard members' views on the phrase. We will propose committee stage amendments to replace the phrase with the phrase "for all intents and purposes," which is more commonly used in other ordinances, such as Section 31 of the High Court Ordinance, Section 73 of the Trustee Ordinance, and Section 3 of the Land Registration Ordinance. Third, administration of oaths and affirmations. Clause 78 of the bill provides that oaths sworn or affirmations made by a participant in a remote hearing may be administered remotely. In practice, the court will direct the conduct of remote making oaths and affirmations in the same way as in physical hearings. When a participant takes an oath or makes an affirmation through a live audio-visual link, the participant still needs to do it in the manner as prescribed in the Oaths and Declarations Ordinance Cap 11. That is, in the case of oath-taking as prescribed under Section 5 of Cap 11, holding the New Testament, or in the case of a Jew, the Old Testament, in the participant's uplifted hand. Nevertheless, in practice, given the different settings in a remote hearing vis-a-vis a physical hearing, there may inevitably be some minor aspects which are technically not identical with each other. For example, no judicial clerk would be present right beside the person to assist that person. Part 2 of the Oaths and Declarations Ordinance sets out taking of oaths and making of declarations in general, including how oaths are to be taken and affirmations are to be made, as well as how oaths and affirmations are to be administered. Clause 17 brackets A of the bill enables the taking of oaths and making of affirmations by way of a live audio-visual link. It is not in contravention with the relevant provisions of Cap 11, so we consider that the present drafting of Clause 17A an appropriate reflection of the intentions, as stated above. Also, in the previous meeting, members put forward comments on the use of terms, and we are grateful for that. We have reviewed these comments, and our replies are specified in paragraph 9 of the document. First of all, we will move a CSA to replace the term caused with direct, with the consequential amendments made to the Chinese version. Concerning clause 26 brackets 5, A2 and B2, we will move CSAs to amend the definition of protected session to clarify that the term breaks does not include the time during adjournment of proceedings. Thank you. Members, any questions? I hope we will not run into any technical issue today. I thank Mr. Jose Yan for his introduction. In particular, I'm pleased that in paragraph 9b, the administration will replace the word cause with direct. I think this is appropriate. Now, I will ask this question for another member's behalf. You're going to replace the phrase "for all effects and purposes" with "for all intents and purposes." We have had a discussion in length on this point last time. Members, are you satisfied that the phrase has aligned with other ordinance. Well, if there are no objections, then I will continue with the clause-by-clause scrutiny. Now, I don't think there are any follow-up questions on the replies given by the DOJ and the Judiciary. We will now continue with the clause-by-clause. Last time, we were at clause 26(1). If there are no questions about this clause, we are going to move on to clause 26 brackets 2, C2468 in the Chinese version. Members who would like to ask questions on this clause, please press the button. Now, Mr. Jose Yam, please continue. Clause 26, brackets 2, a person commits an offense if A, the person, without permission of the court, intentionally publishes an unauthorized proceeding recording or a reproduction of an unauthorized proceeding recording, and B, the person knows that or is reckless as to whether the recording concerned is an unauthorized proceeding recording. Chair, allow me to go to subsection 3 as well. A person commits an offense if A, the person, without permission of the court, intentionally publishes an unauthorized proceeding recording or a reproduction of an authorized proceeding recording, and B, the person knows that the person has no permission of the court to publish the recording or reproduction, as the case may be, or is reckless as to whether the person has the permission of the court to publish the recording or reproduction, as the case may be. Simply put, a person who has made recording or reproduction of an authorized proceeding and the act of publishing the recording or reproduction is a crime. And without the leave of the court, a person who published the recording or reproduction of the proceedings is also an offense. Ms. Lai Tung-kwok. Thank you, Chair. Now, the offense has two conditions. First, without permission of the court and intentional publishing. 2, knowledge that the recording or reproduction is an unauthorized reproduction or recording, or a person is being reckless to this fact. You have a very difficult time proving the person has met these two conditions for prosecution. You have drafted the conditions so narrowly. Is that well thought through? Mr. Jose Yam. Thank you, Mr. Lai. Clauses 26 and 27. These offenses are criminal offenses. The penalties are hefty. If you look at subsection 4, on summary conviction, the penalty is a fine as level 5 and imprisonment for 2 years, or on conviction on indictment, a fine as level 6 and imprisonment for 5 years. That's why we think we have to define the offenses clearly. We won't say this is too loose or too stringent. We just want to make it clear under what conditions are these offenses committed. Now, when a person has no permission of the court and make a recording of a proceeding, and that a person knows that they have no permission or are reckless as to the fact, then they would be committing an offense. And also, without the permission of the court, a person who published the recording or reproduction of a proceeding is an offense. So this covers authorized or unauthorized proceedings. Without the permission of the court, a person who intentionally published the recording is a crime. So the combination is comprehensive. It is clear that these are criminal offenses. Thank you.
黎議員，
Mr. Lai, I have another question. It says here the person knows. Is it that it is referring to the defendant has the knowledge that the recording exists subjectively or objectively? Because down below, there's the word reckless. The word know here is used. Does one have to prove that the person has the subjective knowledge about this or objective knowledge? Judiciary Administrator. Mr. Lai is correct. The word know is used here. Of course, the person will have to have the subjective knowledge about it. There is also the phrase, however, or is reckless as to whether the recording concerned is an unauthorized proceeding recording. I'm reading out from Clause 2A. So if the person knows that or is reckless as to whether the recording concerned is unauthorized, then the person commits an offense. So the word know covers the subjective knowledge. And also recklessness is also one of the elements for the person to commit the offense. Mr. Ambrose Lam. Clause 26, 3A is the same as that of the Chinese version. I mean, the Chinese and English versions, they tally with each other, but for 26, 2A and B, they aren't. For 26, 2B and 3B, they aren't tally with each other. I'm not sure if Mr. Lam is referring to the wording used. Perhaps I'll ask the law draftsman to reply to your questions first. Law draftsman, please. Let us look at subclause 2 first. It is referring to unauthorized proceeding recordings or their reproductions. Nowadays, technology develops rapidly. It's hard to know whether it is the original copy or the reproduction of the original recording. So without the permission, if a person publishes the unauthorized proceeding recording or the reproduction of it will be an offense. And for subclause 3, it is about authorized proceeding recording. The way it is drafted here is different from Clause 2. It's because we want to make it clear that it might involve an authorized proceeding recording or an authorized proceeding recording's reproduction. We draft it differently because we want to ensure the clarity. Well, we're talking about two different offenses here. So, what kind of scenarios are you trying to cover through the difference of the way of drafting here? Well, we've heard Mr. Lam's view. We will try to make the two subclauses consistent. Well, there must be a reason why you drafted two subclauses differently. I just want to know the rationale behind. Yes, sure. No follow-up questions, Mr. Lam? No. I'd like the Judiciary Administrator or the law draftsman to clarify this. Clause 26(2). You use the word no. Sometimes synonyms like aware of or knowingly are used. It is clear the way it is drafted now. And the phrase or is reckless is used. So it shows that if the person knows that or is reckless as to whether the recording concerned is unauthorized, then the person commits an offense. Is it because different penalties will be involved? That's why you use or here? Subclause 3A, it's very clear. It says intentionally publishes an unauthorized proceeding recording. Now, intentionally is more serious. Reckless is less serious. Does it imply different levels of penalty here? Judiciary Administrator. Let me make it clearer, the difference between reckless and no. 2B and 3B is about knowledge and recklessness. As explained just now, if a person has the subjective knowledge, for example in 3B, for example in 2B, if the person knows that the recording concerned is an unauthorized proceeding recording, or in 3B the person knows that there is no permission from the court, then the person commits an offense. For 2B, if the person is reckless as to whether the recording concerned is unauthorized, and for 3B, if the person is reckless as to whether the person has the permission from the court, then the person still commits an offense. So there isn't a difference between the seriousness of the penalty. We just want to make it clear that there are two elements, knowledge and recklessness. Madam Chair just now mentions about the word intentionally used in 3A. (3A) is about a person without permission of the court intentionally publishes an authorized proceeding recording. So here we're referring to an authorized recording, but the person may, without permission of the court, publishes such a recording. Then under such a circumstance, the person commits an offense. Let me see if the law draftsman has anything to add about the word intentionally. Thank you, Madam Chair, for giving us the chance to explain this. There are two parts to this. The first is about the conduct of publishing a recording. According to our instruction, there has to be an intention to publish it in order for it to be an offense. Different people have different knowledge about computers. So if you unintentionally clicks a button and publish the recording, it is not an offense. So we emphasize the word intentionally here. The penalty is heavy. So when we drafted this, we wanted to strike a balance. So in order to make it an offense, you have to have the intention to publish this. And also, apart from having the intention, the person must have the subjective knowledge. That is, the person couldn't care less whether it is an unauthorized proceeding recording. So the second layer to it is about the person's knowledge. So you have to have the mens rea as well as the actus reus. That's why we use the words know, reckless, and intentionally. This is because we want to strike a balance. We want to show that the court respects the court's proceedings. And we don't want anyone innocent to inadvertently break the law. 2B is about unauthorized proceeding recording. And for 3, it is about authorized proceeding recording, but for some reasons you manage to get a hold of such a recording and publish it. So we use different wording to draft these provisions to ensure clarity. We put different emphasis in these provisions, that's why we use different wordings, but we will review how we were able to highlight these emphasis. So again, 2 is about unauthorized proceeding recording and the publication of the recording. And for 3, it is about authorized proceeding recording, and you do not have the permission to publish these recordings. Mr. Lai Tongkok. Thank you, Madam Chair. In subclause 2, the word unauthorized proceeding recording is used. In Chinese, it is 未經授權法律程序記錄. The definition of this is the same as that in clause 26(1). Why are you adding a definition to this in the later part of this clause? Is it repetitive if it means the same as that in clause 26(1)? Ms. Kwok. We want to turn this concept into a label. We want to emphasize that this is a proceeding recording, but it is an authorized one. So we have a definition for that. And we have another term, proceeding recording, here. But here it does not imply whether it is authorized or not. So we have the differentiation between the two to ensure clarity. 26(1), 2, and 3 cover 3 different scenarios. For the first scenario, it's about a person making the act of recording. And for the second scenario, it's about publishing the recording. Publishing, well, having an unauthorized proceeding recording is in itself an offense, and publishing such a recording is also an offense. So we try to cover different scenarios and concepts here. That's why we have two definitions here. That's why under the idea of proceeding recording, we have authorized proceeding recording and unauthorized one.
Mr. Lai, some follow-up questions. In other words, if a person doesn't have the permission of the court and make a recording of the proceeding and then publishes the recording, then they will be charged for two offenses. Am I right? Now the concept is like this. These are different offenses. It depends on the actual behaviors and the actions of the defendant. From the law drafting point of view and according to our instruction, all three actions are considered an offense. Now whether there would be one action being caught by two offenses, it is possible. A person who recorded the proceedings may not necessarily publish the recording. Any more follow-up questions? Mr. Ambrose Lam? It seems that the DOJ has answered my question, but let me confirm my understanding. Subclause 2. As long as the court does not permit the publishing of a recording, a person would be committing an offense if they publish it. Subclause 3, the court has given permission to some parties to publish the recording, but if a party does not have the permission, then they are still committing an offense. So the penalties of the offenses under subclauses 2 and 3 carry the same fine according to subclause 4. So is subclause 2 really necessary? As long as someone does not have the permission, they would be given the same penalty if they publish the recording. Mr. Yam, subclauses 2 and 3, if you look at subclause 2 and 3A, it says without the permission of the court and intentionally publishes. Now, like the law draftsman said, subclause 2 is about publishing unauthorized proceeding recording or a reproduction. Subclause 3 is about publishing an authorized proceedings recording or a reproduction. So subclause 2 means that someone makes a recording themselves without the permission of the court and then intentionally publish the unauthorized recording. Subclause 3 is about a scenario where the court has permitted the making of recording concerning the proceeding or a reproduction. However, someone intentionally publishes the recording, which is legit, without the permission of the court. So this is the difference between an unauthorized proceeding recording or a reproduction and an authorized proceeding recording or a reproduction. Mr. Ambrose Lam, I know there is a difference, but is one already covered by the other so that we can save one subclause? Mr. Yam, we understand where you are coming from, but after all, the penalty is hefty and it is a criminal offense, so we would rather be more lengthy and make it clear. Ms. Karen Kwok, allow me to elaborate. We would like to make distinctions between two scenarios. One is authorized proceeding recording with permission of the court. The other one is unauthorized proceeding recording. That is someone who recorded proceedings without the knowledge of the court. So that is an offense. Publishing it is another offense. For authorized proceeding recording, an authorized party can publish the recording. However, if you obtain the recording and publish it with an unauthorized news agency, that would be an offense. Even if another media outlet is publishing the recording with the permission of the court, you will still be committing an offense. Mr. Lam is right. The severity of the two offenses are different. So there are two conditions: permission of recording and permission of publishing. As long as you get the permission of the court, you will be fine. That's why we are putting them under two different subclauses. Subclause 4, the penalty is the maximum penalty. So depending on the severity of the offenses, the court can hand down an appropriate sentence. So maybe subclause 3 is less severe because the recording published is authorized by the court after all. But subclause 2 is making a recording without the authorization of the court. So since we have set out the maximum penalty, we would leave it in the hands of court. So you may be sentenced to the maximum fine or imprisonment if you committed any offense under all three subclauses. Thank you for explaining the legislative intent to me. Thank you. On this point, I would like to follow up on the reply from the Judiciary Administrator. Now, as long as you have knowledge and it's reckless to the acts, that you would be committing an offense and they carry the same penalty. So can I say that the maximum penalty for all three offenses are the same? Under the common law system, our courts are experienced as to whether a person has the intention or is reckless to the act that would make a difference in sentence, and also whether there is material omission. So, in other words, the maximum penalty is the same. In terms of sentencing, intentional or being reckless do make a difference. Is that right? Mr. Yam? Thank you. Chair, you are right. The penalties set out in subclause 4 are the maximum sentence, whether it is a fine or imprisonment term. The offenses under subclauses 1 to 3 spell out the behaviors or actions which would constitute an offense. Under the common law principle, courts would consider the severity of the actions and the strength of evidence and hand down various sentences. We would leave that to the courts to decide. We can't say exactly what sentences would be handed down. Thank you. That's for the public's knowledge only. Now, under clause 26, if someone commits these acts with knowledge or are being reckless as to these behaviors, they will be given a sentence. The sentencing guideline is the same, but there is a difference between intentionally doing so and being reckless as to the behavior. That will be decided by the court based on the circumstances of the case. So in reality, there would be a difference in sentencing. Next, Mr. Holden Chow. Thank you, Chair. My question is about a real-life scenario. If someone commits an offense, the law has to be enforced. But we do understand that it is more important to prevent such offenses from being committed. Now, being intentional or not carries a difference. I get that. But what if someone mistakenly or carelessly published the recording but have taken reasonable actions to remove the uploaded recordings within a reasonable time frame? Will that constitute a reasonable excuse? It's not a defense because no defense is set out in the bill. Sometimes the fact would only occur during cross-examination of the defendant. So if during the course of trial it is proven that someone has taken all reasonable courses to remove or delete the video within a reasonable time, can it be an excuse proving that they had no intention to publish the recording in the first place? I seek some clarification here. Mr. Holden Chow mentioned several important points just now. Now, like I said at the beginning, we are bilingual. So, members, when you speak, if you speak in English, please also translate what you said into Chinese as well. That's for the public's interest. Mr. Yan, thank you. Clauses 26 and 27. Now, both clauses set out what actions or behaviors constitute an offense, and also the combination of offenses. Second, the maximum penalty. So, as I have explained just now, the penalty would apply to all offenses. So what Mr. Holden Chow mentioned is about the operations of the court. Now, when someone has committed an offense, the prosecutorial decision is in the hands of the DOJ, considering the strength of evidence and the conditions of the offense. If the DOJ decides to prosecute the case, then the case would be left in the hands of the court. Of course, the defendant would be given an opportunity to defend themselves. As Mr. Holden Chow said, the strength of evidence and the circumstances behind each case is different. So we don't want to usurp the authority of the court to define what makes a defendant guilty and also what sentences should be handed down. If a person carelessly committed the offense but has taken immediate remedial or corrective measures, then I believe that these circumstances would definitely be considered comprehensively by the court. That is in the power of the court. Any more follow-up questions? So the court would consider the actions taken by the defendants and make a decision. If there are no other questions concerning this clause, I will invite Mr. Yam to move on.
Judiciary Administrator, please. Subclause 4, which was touched on just now. A person who commits an offense under this section is liable A. on summary conviction to a fine at level 5, that's $50,000, and to imprisonment for 2 years, or B. on conviction on indictment to a fine at level 6 and to imprisonment for 5 years. A level 6 fine would be $100,000. So whether the person will be convicted on summary conviction or On indictment, it will be decided by the prosecution department. Now, subclause 5 covers a number of definitions. Authorized proceeding recording means a proceeding recording made with permission of the court. Protected session. This was explained in the previous meeting, so I'm not going to repeat it again. Proceeding recording means a recording of either or both of the following: A protected session of a proceeding, B, a protected subject in relation to a proceeding. Courtroom means a place in a court building where a proceeding is being conducted regardless of the mode of hearing for the proceeding. We got a question from the legal advisor. The legal advisor advises us to use two different references, that is, the designated court premises in Schedule 2 as well as courtroom. We will move a CSA on this. Protected subject in relation to a proceeding means A, the courtroom in which the proceeding is conducted, or B, any person appearing in the courtroom. Specified person in relation to a proceeding means a JJO, a juror, or a participant in respect of that proceeding. Lastly, authorized proceeding recording means a proceeding recording made with permission of the court. That's all for subclause 5. Any questions from members? Judiciary Administrator, please carry on. Clause 27, offences of recording and publishing broadcast. The way 27 is drafted is very similar to that of Clause 26. So the wordings are very similar. Clause 26 is about recording and publishing protected sessions and protected subjects. Here, in 27, it's about offences of recording and publishing broadcast. 1. A person commits an offence if the person, without permission of the court, intentionally records a broadcast under Section 24 or a broadcast of a physical hearing. 2. A person commits an offence if A, the person without permission of the court intentionally publishes an unauthorized broadcast recording or a reproduction of an unauthorized broadcast recording, and B, the person knows that or is reckless as to whether the recording concerned is an unauthorized broadcast recording. 3. A person commits an offence if A, the person without permission of the court intentionally publishes an authorized broadcast recording or a reproduction of an authorized broadcast recording, and B, the person knows that the person has no permission of the court to publish the recording or reproduction, or is reckless as to whether the person has the permission of the court to publish the recording or reproduction. 4. A person who commits an offence under this section is liable A, on summary conviction, to a fine at level 5 and to imprisonment for 2 years, or B, on conviction on indictment, to a fine at level 6 and to imprisonment for 5 years. 5 covers a series of definitions. Unauthorized broadcast recording means a broadcast recording made without permission of the court. Broadcast recording means a recording of A, a broadcast under Section 24, or B, a broadcast of a physical hearing. Authorized broadcast recording means a broadcast recording made with permission of the court. That's all from me for this part. With no questions, yes, Mr. Lai Tong Kwok. We spent some time on Clause 26 about authorized and unauthorized proceeding recording. Now, in Clause 27, there is a definition spelling out what it means by authorized broadcast recording and unauthorized broadcast recording. How come it is spelled out so clearly here what is authorized and unauthorized broadcast recording? But in 26, there is only the definition of authorized proceeding recording. We had the discussion just now because there wasn't a specific definition about unauthorized recording. Will you draft the two clauses in the same way so that they tally with each other and that in future, when people read this, they will have a better understanding of it? Chairman, I'm not sure if I understand Mr. Lai's questions correctly. In fact, in clause 26, subclause 5, we have at first the definition of unauthorized proceeding recording. It means a proceeding recording made without permission of the court. And lastly, we have the definition of authorized proceeding recording. I'm not going to read out the definition here. So in clause 26, we do have the definitions of unauthorized proceeding recording and authorized proceeding recording. In clause 27, subclause 5, again we have at first the definition of unauthorized broadcast recording, and in the end we have the definition of unauthorized broadcast recording. So be it authorized or unauthorized broadcast recording, or authorized or unauthorized proceeding recording, we have the definitions for them here. Chairman, let me make myself clearer. Clause 27, subclause 5. There's the definition of unauthorized broadcast recording. There is also the definition of authorized broadcast recording. When we had a discussion about clause 26, bracket 2 and bracket 3, we talked about authorized and unauthorized proceeding. If you look at clause 26, subclause 5, you have the definition of authorized proceeding recording. But you don't have the definition for unauthorized proceeding. But in clause 27, you do have the definitions of both. My question is, since you have the two different definitions in clause 27, would you apply the same to clause 26 so that the clarity can be enhanced? Judiciary Administrator. I'm not sure if I understand what Mr. Lai said correctly. The first definition in clause 26 is unauthorized proceeding recording. It means a proceeding recording made without permission of the court. We had a discussion about 26 bracket 2 and bracket 3, and those two subclauses are about authorized and unauthorized proceedings recordings. So whether the proceeding recording is authorized or unauthorized, we have the definitions here. If members of the view that our definition isn't clear enough, we can review them. Let's move on to clause 28. Judiciary Administrator. Supplementary provisions to sections 26 and 27. Evidence by certificate for permission of court. 1. In a proceeding brought under section 26 or 27, A certificate stating that a specified permission is not given by the court to a person and purporting to be signed by or on behalf of the Judiciary Administrator is admissible in evidence on its production without further proof. 2. Unless the contrary is proved, a certificate admitted in evidence under subsection 1(a) is presumed to be signed by or on behalf of the Judiciary Administrator as the case may be, and (b) is evidence of the facts stated in the certificate. 3. In this section, specified permission means a permission to do an act that would otherwise constitute an offense under Section 26 or 27. Simply put, if a person is alleged to commit any offenses set out in clauses 26 and 27, then the prosecution department would consult the judiciary. If it is found that the person has no permission to commit those acts, then there would be a certificate for permission of court to be admissible as an evidence. We have drawn reference from other legislations in Hong Kong, and a similar way of drafting this kind of provisions is used in other legislations. This is to offer assistance to the prosecution department. I see that members have no questions about this. Let's move on. Clause 29. Defense regarding reasonable excuse. 1. It is a defense for a person charged with an offense under Section 26 or 27 to establish that at the time of the alleged offense, the person had reasonable excuse for the contravention. 2. A person is taken to have established the reasonable excuse for the contravention if (a) there is sufficient evidence to raise an issue with respect to the reasonable excuse, and (b) the contrary is not proved by the prosecution beyond reasonable doubt. On the 9th of January, when we replied to the inquiries made by the legal advisor, please refer to CB bracket 233/2025 bracket 01. Paragraph 12 of the paper touches on this. We've actually explained about this as well. It sets out examples about what are reasonable excuses. Say, for instance, during a court proceeding, there is a medical condition, or a person during this circumstance films the situation, then this could be a reasonable excuse for filming the proceeding. I have a question here. Whether the excuse is reasonable, are you referring to how the defendant looks at it, or are you referring to how the court looks at it? Now, whether an excuse is reasonable, we leave it to the court to decide. In terms of the wording, I'll invite the law draftsman to supplement.
Thank you. Clause 29 is about defense regarding reasonable excuse. The person charged has the burden of evidence. So like the chairman said, there is an objectivity to it. Of course, if you raise a defense, you must think it reasonable. So according to past authorities, the court would look at whether the excuse is apparent to anyone, and also the objectivity of the excuse. So of course a person would raise their own defense, but it would be in the hands of the court to judge the reasonableness of the excuse. So it's a test of subjectivity or objectivity. If the court reads the provisions as a test of objectivity, what happens? If that's the case, we don't have to give regard to what the defendant thinks. We just have to conduct the test of objectivity. Now, whether a defense is a reasonable excuse is objective, but the action of raising the excuse or defense is a subjective one. Whether the reasonable excuse stands depends on the objectivity test conducted by the court. So for the court, the judge would adopt an objective standard to decide whether the excuse is valid. But does the provision allow the court to accept a subjective test of excuse or defense? Even if most would think that the action is an offense or the defendant is culpable, but say if the defendant is mentally incapacitated or mentally challenged, then the court may find it a reasonable excuse. Now, Clause 29 says that a person being charged with an offense under Section 26 or 27 can allege reasonable excuse. And the person has to raise sufficient evidence to support the claim, and the contrary is not to be proved by the prosecution beyond reasonable doubt. So in short, this is an objectivity test. But this is a clause of statutory defense, and in such a case, the defendant would be allowed to raise their own evidence or their points. So the provision doesn't say that as long as the person considers it a reasonable excuse, the court has to consider it. That's not the case, right? Now let me elaborate. It means that the person has to raise sufficient evidence to prove the excuse. Now, because the subject is a person charged with an offense under Sections 26 or 27, so the person is responsible for proving the claim. So the objectivity test is not to be conducted by the person raising the defense. Like the law draftsman said, a person charged with an offense under Section 26 or 27 has to establish that the person has reasonable excuse. So the person means the accused. I agree. We phrase the provision so because we want to emphasize that the person has to raise the evidence themselves. So it is very clear it is an objective judgment to be made by the court. Of course, in a legal case, everyone would say that they have grounds. So in any event, the bottom line is the test is an objective one. Thank you. Mr. Paul Jack. Thank you, Chair. Allow me to wade in to clarify the issue. I think the law draftsman has misunderstood the point raised by Mr. Ambrose Lam. Of course, the person raising the defense will be doing it for their own sake. It is a subjective one. However, in court, the court has to conduct two steps to judge the objectivity of the excuse. First, whether the court accepts that the person has the intent behind the actions. And in considering that, the court will also consider the background and the upbringing of the accused. And the second step is to consider, given the background of the defendant, whether the reaction is a reasonable one. So there are two steps to be taken. It's not about the subjectivity when the argument is raised. It's about the testing of the claim. So the court was first established that the accused subjectively has a subjective thought when the action is being committed, and then the other step would be to test whether the response made is reasonable according to most people. So this is the common practice adopted by the court whenever the provision is like that. So I think the law draftsman has misunderstood the question of the chairman. It's not about raising the defense, it's about the test of the reasonableness of the defense. You're right, Mr. Portier. Thank you. Let's move on. We've now come to Clause 30, Part 6, Miscellaneous. Clause 30, General Power of Chief Justice. Subclause 1, the Chief Justice may designate certain types of proceedings, except for excluded proceedings, as the type of proceeding to be conducted through a remote medium. That is, designated type of proceeding. Subclause 2, in making a designation under subsection 1, the Chief Justice may also A. Provide that the court may order a different mode of hearing for a proceeding, even if it falls within the designated type of proceeding. And B. Specify the factors that have to be considered by the court before making an order under paragraph A. I will pause here. I would like to address the questions raised by the legal advisors when we have come to Clause 32. No question for 30. 31. Power to amend schedules. The Chief Justice may, by notice published in the Gazette, amend the schedules. Please continue. Ms. Lai Tong-kwok. About Clause 31. Now, in exercising the power of Chief Justice, is it a negative vetting process? That is right. Now, I think the most important part in the schedules is Schedule 1, excluded proceedings. Now, there are two at present. In other words, the Chief Justice is empowered by this clause to amend the schedule. That is, they can add more proceedings to the schedule, or, in theory, remove the two excluded proceedings from Schedule 1 with a negative vetting process. Now, in Clause 6, we were clearly told that excluded proceedings cannot be touched. You spelled it out clearly in Clause 6. However, you have given the Chief Justice power to amend the schedule. In effect, Clause 6 didn't matter. To change the schedule, the Chief Justice just need to go through a negative vetting procedure and amend the schedule about excluded proceedings. So would you consider reverting it back to positive vetting? In other words, if the Chief Justice is to amend Schedule 1, they have to first go through a positive vetting process to reflect the importance of this schedule. Thank you, Chair. Thank you, Mr. Lai, for your questions. Mr. Lai's understanding is correct. The Chief Justice can amend the schedule by way of negative vetting. Now, what are excluded proceedings? When we explain the policy intent of the bill and during the clause-by-clause process, we have reached a consensus that for criminal trials and also juvenile trials in juvenile court, these trials or these proceedings should not be conducted by way of remote hearing. However, at some point in the future, there may be a consensus that even criminal trials can be conducted by way of remote hearing. That's why we have included these two types of proceedings in Schedule 1, and we have provided a cause to amend the schedule. Whether it is positive or negative vetting, it is still a statutory procedures. We have clarified in the bill that criminal trial and hearing before the juvenile court are excluded proceedings, not to be conducted by remote hearing. So both positive and negative vetting are serious scrutiny process. We would like to give the Chief Justice some room for maneuvering to amend the schedule for the benefit of the operation of the court. Now, Schedule 2 is just about the addresses of court premises. So before amending Schedule 1, I believe that the judiciary would consult the trade comprehensively, so we still think negative vetting is appropriate. I understand where Mr. Lai Tong-kwok is coming from. Do other members share the same concern? Now let's move on. Clause 32. Chief Justice may make rules or give directions. The Chief Justice may make rules or give directions regarding any or all of the following. I will pause here. The legal advisor has raised a question on this clause. Now we would like to clarify that the rules we are talking about here are subsidiary legislations subject to negative vetting by the LegCo. Directions given by the Chief Justice means practical directions given by courts. I will move on to subclauses A to F. Subclause A, the designation for the purposes of the definition of remote medium in Section 2. Subclause B, the application for a remote hearing order under Section 6. C, the application for variation or revocation of a remote hearing order under Section 7 or 8. D, the procedures and practice to be followed by courts in conducting a remote hearing. E, the giving of evidence through a remote medium. F, the administration of oaths and affirmations under Section 17. G, the transmission of documents for the purposes of a remote hearing under Section 19. H, the presentation of objects for the purposes of a remote hearing under Section 20. I. The signing of or the writing on documents for the purposes of a remote hearing under Section 21. J. The broadcast of an open proceeding under Section 24. K. The designation under Section 30. And L. The better carrying into the effects of the provisions and purposes of this ordinance. Now, from subclauses A to L, these are about the practical operation of courts. Generally speaking, these would be specified by way of practical guidelines handed down by the court for the trade's interest. Thank you.
Any questions? Yes, Mr. Lai. Thank you, Chairman. I have the same question. When the Chief Justice makes rules and gives directions, would that be made in the form of subsidiary legislation? Yes. The rules that we are referring to here will be a subsidiary legislation, which will be subject to negative vetting. And in relation to the practice directions that I mentioned, they would be the court's practice directions. So the rules will be in the form of subsidiary legislations, but directions not. How do you differentiate the two? This is because they belong to the same clause. Well, how would you justify this? This is because they are included in the same clause. It is not spelled out here that the directions to be given by the Chief Justice will not be in the form of a subsidiary legislation. Would this generate confusion? In paragraph 14 of our reply to the legal advisor, it is said that for subclauses A to L, any rules or any directions to be given that that concern the technical details, they will be given in the form of a practice directions. As mentioned, subclauses A to L, they mostly concern the operations of the court, so they will mostly be made in the form of a practice direction, even without this clause. Currently, courts have the case management power to make case management decisions. It is just that here, the rules and directions will concern specifically remote hearings. So the clause will give a better direction in the sense of how the judiciary can carry out its work. This is not something new. It is just that the judiciary will be able to make rules or give directions better. Mr. Lai. In the same clause, you include rules and directions. One will be made in the form of the subsidiary legislation and the other not. Will that be a problem? You may want to define clearly that the directions to be given will not be in the form of a subsidiary legislation, while the rules to be made will be in the form of a subsidiary legislation. This will not affect the power to be exercised by the Chief Justice. It's just that these two are included in the same clause. There might be unclarity because you are not spelling out clearly which are considered as subsidiary legislations and which aren't. If you spell it out clearly, it will enhance clarity. My view is that you differentiate the two. Yes, Department of Justice. Legal advisor. We earlier wrote to the administration about Clause 32. We would like to see clarification on this. Subclauses A to L. Will some of these subclauses only be made in the form of a subsidiary legislation? Will there be situations where rules have to be made and at the same time directions will have to be given? We asked the administration to break up Clause 32 into two parts. One part concerning ways for the Chief Justice to make rules, and the other part about the Chief Justice giving directions. Our question is set out in Annex of paragraph 13 of paper CB 1716/2024-01. We've got the reply from the administration. We will ask members whether they support this. Judiciary Administrator, we thank Mr. Lai for the suggestion. Clause 32, bracket A to bracket L. They concern the operations of the court. In our reply to the legal advisor, we mentioned that normally we make use of the practice directions when we want to sort out the technical details or operations of the court. We want to allow a certain level of flexibility. So that when subsidiary legislation has to be enacted, we can make use of that. But as mentioned, for subclauses A to L, these kind of matters can be dealt with in the form of a practice direction. These are about the technical matters or the operations of the court. The way the clause is drafted now is to allow for a level of flexibility. We understand Mr. Lai's concern, but we have thought about it, and that's why we have drafted it this way. Of course, we will give a second thought to it, but we have thought it through before we drafted this. Mr. Poche, you want flexibility as well as certainty. Where should the balance lie? Bracket A to bracket L. Which one is likely to be dealt with by subsidiary legislation instead of practice directions? Is it necessary to have the level of flexibility you mentioned? For subclauses A to L, under what circumstances will the matter be dealt with in the form of subsidiary legislation? Judiciary Administrator. As mentioned, most of these matters can be dealt with by the practice directions. However, there might be scenarios that we cannot think of now. In case these scenarios come up in the future, we will have the flexibility to deal with them by way of subsidiary legislation. Like Mr. Poche said, we need flexibility and at the same time certainty. but under normal circumstances, a practice direction should suffice in dealing with these matters. Normally, when rules are made or directions are given, it is clearly set out whether they are subsidiary legislations or practice directions. I guess we don't have to be too concerned because rules and directions are often put together in the same context. Like the legal advisor said, you might want to split it into two parts. However, very often these two are put together. I think in practice this is feasible. Clause 33. Judiciary Administrator may issue administrative instructions. The Judiciary Administrator may issue instructions of an administrative nature relating to any or all of the following. A. The technical details and standards of a remote medium. B. The hardware, software, equipment, and other technical requirements for participating in a remote hearing. C. The details of pre-testing requirements and contingency measures. D. The details for the broadcast of an open proceeding under Part 4. And E. Any other arrangements for facilitating the conduct of a remote hearing. Administrative instructions are included in other legislation such as Cap 683. This is the law governing the integrated case management system. The Judiciary Administrator may issue administrative instructions. They relate to, for example, the specifications of hardware or software and equipment. In paragraph 15 of our reply to the legal advisor, we talked about clause 33 bracket C. The details of pretesting requirements and contingency measures, these are considered to be part of the operations of the court. They may have to be adjusted from time to time in response to the development of technology. So we think that it is not appropriate to set out clearly these details so that there is a flexibility for the Judiciary Administrator to issue instructions. Part 7. Transitional provisions. Clause 34. Interpretation for Part 7. 1. In this part, commencement date means the day on which this ordinance comes into operation. Existing proceeding means a proceeding that has not yet been disposed of on the commencement date. Subject provision means Section 79I of Cap 221. That is, the Criminal Procedure Ordinance, as in force immediately before the commencement date. 2. In this part, a reference to a proceeding to be conducted remotely is a reference to a proceeding to be conducted through a live television link or any other facility for remote communication. The television link mentioned here corresponds to Section 79I of Cap 221. Clause 35. Transitional arrangements for existing proceedings that are NS proceedings. This is similar to Clause 36. Let me brief you on 35 first. 1. For an existing proceeding that is an NS proceeding, A. Every application made before the commencement date under the subject provision in the proceeding is to be regarded as having been withdrawn. B. Every application otherwise made before the commencement date for the proceeding to be conducted remotely is to be regarded as having been withdrawn. C. As long as a verdict has not yet been delivered in the proceeding, every permission given under the pre-amended subject provision in the proceeding is to be regarded as having never been given. And D. As long as a final judgment has not yet been rendered in the proceeding, every order otherwise made before the commencement date for the proceeding to be conducted remotely is to be regarded as having never been made. 2 in this section. Pre-amended subject provision means Section 79I of Cap 221 as enforced immediately before the 23rd of March 2024. As you may recall, the 23rd of March 2024 is the date on which the Safeguarding National Security Ordinance came into effect, and Section 79I of Cap 221 was amended in this ordinance.
In short, Clause 35 says that remote hearing does not apply to any national security proceedings. So, of course, national security cases cannot be conducted by way of remote hearing. Mr. Lai Tong-kwok, I would like the Judiciary Administrator to tell us that before the transitional arrangements come into effect, are there any national security cases being conducted by remote hearing? Chair, according to my understanding, so far, no national security proceedings have been conducted by way of remote hearing. If that's the case, subclauses C and D are actually unnecessary. For some cases, before they start, they will be classified as national security proceedings. For some other cases, national security elements may be discovered during the trial, and then they will be classified as national security proceedings. So in drafting the bill, we would like to err on the safe side. So we want to specify clearly that whether it is the transitional arrangements or the full arrangements, remote hearing do not apply to national security proceedings. Please continue. Clause 36. Transitional arrangements for existing proceedings that are not NS proceedings. 1. For an existing proceeding that is not an NS proceeding, every application made before the commencement date under the subject provision in the proceeding is to be determined as if this ordinance had not been enacted. B. Every application otherwise made before the commencement date for the proceeding to be conducted remotely is to be determined as if this ordinance had not been enacted. C. If permission has been given before the commencement date under the subject provision in the proceeding, the old law continues to apply in relation to the taking of evidence from a witness outside Hong Kong. And D. Every order otherwise made before the commencement date for the proceeding to be conducted remotely continues to have effect until the disposal of the proceeding. Subclause 2. In this section, old law means A. Part 3B of Cap 221 as enforced immediately before the commencement date, and B. The live television link witness outside Hong Kong rules Cap 221/L as enforced immediately before the commencement date. Simply put, non-NS proceedings in progress before the enactment of the bill, they will be dealt with under the existing mechanism. Thank you. You may continue. We are now at Part 8. Part 8, related amendments. We will revisit Schedules 1 and 2 at C2029. Chairman, would you like me to go to Schedules 1 and 2 first? Yes, please, and then we will go back to Part 8. We have discussed these two schedules before. Schedule 1 includes excluded proceedings. 1. A criminal trial. 2. A hearing before the juvenile court. Schedule 2. Court premises. These are the addresses of our courts. Chairman, do I need to go through all the addresses? Members, do you think that is necessary? No. No, this is a 3-hour meeting, so maybe we will take a break and then move on to the related amendments. Let's take a 5-minute break. I see some of you nodding. Let's take a 5-minute break then.